Hello. This is the third talk in a series brought to you by the Foyle Product Liability Sector Focus Team. It follows the splendid talk by Karishma Paroba on genomics and COVID-19. I'm Neil Block, a QC practicing at 39 Essex Chambers. My practice includes singular and multi-party product liability claims in relation to personal injury or property damage. There now follows a brief introduction to product liability and product recall in the UK. I'm going to start by looking at product safety, regulation, and compliance. Now, the essence of product liability law, as you all know, is the protection of the consumer. Manufacturers, importers, distributors, and sellers of consumer products are responsible for making sure that they're safe for consumers to use. And this includes following the legal requirements for labeling. The General Product Safety Regulations 2005 require all products to be safe in their normal or reasonably foreseeable usage. The Consumer Protection Act 1987 requires them to be free from defect. The Sale of Goods and Services Act 1979 requires them to be reasonably fit for purpose. I'm sure you're getting the message. When the requirement under the 2005 regulations is not met, central government or local authorities and other regulators may take appropriate action. And particular products may have to comply not only with the general product safety regulations, but also with specific regulations. Obvious examples are food, drugs, and motor vehicles. Manufacturers and importers placing products on the UK market need to demonstrate that they comply with relevant safety requirements. In practice, this involves minimizing the risks associated with the product, generating and keeping records of associated technical documentation, placing appropriate labeling and packaging on the product, and providing instructions for safe usage. Now, inevitably, in my view, inevitably, manufacturers, importers, distributors, and retailers will, from time to time, become aware of safety risks or consumer incidents or claims relating to their product. They should report these matters to their local trading standards service, and they should also consider appropriate corrective action, including provision of information and recalls. The Trading Standards Department will place the product on its recall list if necessary. Now, any product that has a safety risk must be recalled unless provision of information, for example, modified operating instructions or some other course of action short of recall will remove the safety risk. Manufacturers are required to publish a notice in a form and manner that will bring to the attention of purchasers the risks the product poses and the facts of the recall. Now, a much repeated criticism of the present UK system is that there's no single enforcement body that monitors and recalls potentially unsafe products. Under the Consumer Rights Act, the purchaser of an unsafe product is entitled to a full refund. Under the Sale of Goods and Services Act, the purchaser may claim a refund or a replacement product. When the safety of a product is called into question, it can have far-reaching, serious and long-term or even permanent effects on a product or business. I'm sure that you can all think of examples of this. Once a decision to recall is made, consumer and media reaction may be quick and impact on business can be extremely damaging, with business value, consumer confidence, and sales revenue falling sharply. The manufacturer will therefore not take the decision to recall lightly. Having a planned and well thought out approach to spotting safety issues and a system to gather information and analyze its potential significance is therefore business crucial. Whilst a product that does not perform as intended is not good, another consequence of manufacturing, importing, distributing, and selling a defective or unsafe product is that the consumer may be injured or their property may be damaged. And this may in turn lead to claims for damages to compensate for personal injury or damage to property. Whilst there may be claims in tort and contract, the most straightforward claim will usually be under the Consumer Protection Act. The key issue on which the court will be focused is whether a product is as safe as persons are generally entitled to expect. Liability under the Act is strict. If a consumer can prove defect, causation, and damage, then they will succeed. There's no need to prove fault, in other words, negligence on the part of the manufacturer. Whether a defect exists and whether there's a causal link between the defect and damage are usually the central issues in product liability claims. The court may be invited in determining these issues to consider expert evidence, particularly with regard to electrical, mechanical, pharmaceutical, and medical device claims. Now, such claims may be expensive, although insurance will usually be in place. On the other hand, for a product recall, the stakes are often much higher. A brand reputation which has been built up over many years can be destroyed overnight. Now, whilst there may be insurance in place to cover the actual recall, the business may be severely or even irreparably damaged. It's therefore perhaps unsurprising that high-level risk assessments and decisions about whether corrective action short of a recall can be taken are extremely difficult. There will be a tension between the desire to protect the public and the desire to protect the business. There will often be a need to act quickly. Indeed, there are time limits in the regulations. A company must inform a regulator of a potential safety issue, and criminal penalties will attach to any delay in making such a notification. Coupled with this is the huge responsibility that comes with taking the decision to recall a product. Businesses, in my view, should have a plan in place to determine whether a recall is necessary and, if so, to manage the recall effectively, mitigate the reputational implications, and minimize the danger to the public and the loss of revenue to business. In-house lawyers and external legal advisors will usually need to be involved in devising and implementing the plan. Taking proactive steps can significantly improve how the recall is viewed by the public and the media and limit damage to the business. Systems should be in place to assist the early identification of potential safety issues. Generally, the earlier a problem is identified, the less damage will have been done and the more options will be available to the parties with a potential liability. A sophisticated approach to gathering information, analyzing it, and identifying safety issues as soon as possible will usually, perhaps always, be money well spent. If issues can be spotted early on, then the businesses can act before there is any significant injury or damage to the property. This should assist giving a positive message to the market, even if the ultimate action is a recall. It will be possible to say that the company's proactive internal monitoring systems have identified a potential safety issue and that prompt action is being taken to ensure the safety of customers. Now, prompt notification to regulators and to consumers will generally be beneficial to the producers as well as the consumers. Regulators encourage early notification of potential safety issues, even if information is still being collated and risk assessments are still in progress. understandably, manufacturers are often loath to do this, as the completed risk assessment may ultimately conclude that there's no safety issue and that, in effect, there was no need to let their concerns be known more widely. This is another example of the tension between the desire to protect reputation and the benefit of early notification to the regulator as soon as a potential safety issue arises. Now, depending on the industry concerned, the time frame within which a company must notify regulators can be very short. A matter of days if the risk is serious, and failure to do this may involve criminal sanctions. Also, if the product does have safety risks, failing to act promptly on available information may well have negative reputational implications, both in loss of business and media criticism. Now, I should just briefly mention civil claims for compensation for breach of contract, negligence, and under the Act. The authors of Clark and Lindsell suggest that where a product is unsafe or dangerous after it's left the manufacturer's control, there may be a duty to recall that product. And they refer to the General Product Safety Regulations 2005 Regulation 15, by which the Secretary of State or a local authority may require recall of any product reasonably believed to be dangerous. And further, if a consumer can subsequently prove that they would have heeded such a recall and by doing so avoided injury or damage to property, they will have a potential cause of action against the manufacturer. Somewhat surprisingly, there's only one case that I'm aware of, and it's an unreported 1978 case called Walton and British Leyland. Finally, and perhaps unsurprisingly, if a recall is made and the manufacturer fails to render the product safe, then it may be liable for subsequent injury. Again, surprisingly, there's no United Kingdom case that I found, but there's a Canadian case, Hutton and General Motors of Canada, in which airbags on vehicles that had been recalled and supposedly adjusted, deployed when they shouldn't have done when vehicles were used, resulting in personal injury. And a modification carried out on the recall was held to have been inadequate. So under the Consumer Protection Act 1987, the most straightforward route for compensation is provided, whereby all that the consumer will need to establish is defect, and one can expect to see more claims of that type relating to recall or other inappropriate measures in the future. Well, thank you for listening to that brief introduction to product liability and product recall. I hope it's given you some food for thought and perhaps pointed you in the right direction if you come across such a case in the future. The next talk in this series will be presented by Dan West on the subject of Section 41 of the Consumer Protection Act. And it's an interesting talk, and I can commend that to you. Thank you very much. Goodbye.